Loved ones, Management 3234. This is session 21. If we were face to face, it would be 20 July 2020. We're going to spend some time with chapter 15 in a moment, intellectual property and legal forms of business. I want to point something out, though, that's actually quite distressing to me. I am speaking to you from room 1104 at the Parker College of Business. This is a tiered classroom that is literally right across the hall from my office. So proximity is good because I have to drag stuff back and forth for these filming sessions. Also, I don't know if I've shared this with you at any time in this summer session, but because of the time compression, because of the fact that we try to pull this off in 4.5 weeks, the fact that I present classes essentially 5 days a week for multiple sections, the pace of summer school limits my choices. When I was forced to go online in the spring, I literally did a couple of classes at a range in coastal Georgia. I filmed one in the CIA safe house. We'll talk about that later. But one of the reasons that there's benefit to me using classrooms in the Parker College, I know I've shared this with you. There are times when I have to use the whiteboard. I think that's helpful because many of you I know are visual learners, and I don't think I can competently present a lot of concepts without the ability to model it or put it on a whiteboard. And then there are times, as you know, that I use the projection tech that's in here, that I've got PowerPoint presentations that are on folio that I want to work through with you. So a lot of my classes have been taught in 1104 in this summer session. There's been a traumatic event, a seismic change. I have no idea the lasting impact of this event. What I have to do is I have to rotate the camera a little bit to my right. I'll bring it back. All right, I'm gonna have to walk over here now. Yes, this is so sophisticated, would you agree? There's a wooden wall plate where my hand is, and up until a few days ago, there was a pencil sharpener there. The pencil sharpener is gone. What sort of a universe are we living in when pencil sharpeners leave classrooms? I'm just stunned. So let me go back because I've got some important questions that we need to ask. I don't know the answer to this. Do you suppose it was removed because of a COVID-19 protocol? I mean, we all know I have to wear masks and condoms and wax our cars every 6 months or whatever it is that they tell us every other day. Was it theft? Did some rat son of a gun come in here and misappropriate that thing? How about new tech? Is there any new technology that puts a point on a wooden pencil that has displaced a mechanical pencil sharpener? Retirement. I don't know how old it was, 30 years, something like that. Do pencil sharpeners, are they eligible for retirement? Is there some other explanation? I'm stunned. The pencil sharpener is gone. Antifa, maybe? The people from Portland, Oregon? They're a bunch of stoners. All right, so pretty scary stuff, but I had to share that with you because it is life-changing, yes. So now I want to jump into chapter 15, legal and IP issues, intellectual property issues. Here's a reality about the legal concerns of a business. None of us as lay people, as non-attorneys, know enough about business-related legal issues to be either able to do it ourselves or to neglect it. We literally don't know what we don't know. That may sound like some fun, folksy saying, but that is the definition of radical ignorance. I do a fair amount of scholarship, a lot of research in decision-making, particularly in entrepreneurship, but in other domains as well. And for that reason, from time to time, I immerse myself in the literature of cognition in the domain of psychology, how people think. And literally, in that domain is where I discovered this definition. The definition of radical ignorance is we don't know what we don't know. So my point is, it's easy to build a bridge from radical ignorance to us not having any credential with respect to the legal affairs of a business to decide if we should try to do it ourselves or if we are safe to ignore it, because we don't know what we don't know. So I want to talk about a number of topics inside this domain of the legal affairs of a business. The first thing I want to point to that might be helpful, truly helpful, especially if you are aspirational, if you want to become an entrepreneur, is the Small Business Administration is a federal agency, and it's an uncommonly good one because it generates enormous benefit to the entire business community. The small business community in this country is huge, something to the order of 18 or 20 million small businesses. So the Small Business Administration has a couple of resources that would be very, very helpful in this domain of what are the legal affairs or legal concerns of a business. The SBA has a group of people, generally they are literally retired executives. They belong to a volunteer organization called SCORE. SCORE is an acronym that stands for Service Corps of Retired Executives. And it is populated by people with decades of industry experience. When I started my accounting practice in 1975, that's a long time ago, 45 years ago, I went to the SCORE office in Atlanta because I wanted guidance on credit and collections. I knew accounting, but I didn't know an awful lot about extending credit to clients or wholesome collection procedures or protocols or policies or anything else. And the counselor that was assigned to me free, this man met with me dozens of times, became a treasured friend, was a guy named Rex Daig. You don't need to remember his name, but Rex spent 35 years in banking and financial services in credit and collections. Okay, so there's a lot of horsepower there. So my point is, the SBA has a group called SCORE. They exist in every major city. We have a group here in Statesboro, though we don't make the cut of a major city. We're just an actual pretty cool place to live. So I want you to be aware of the fact that the Small Business Administration all over the nation has these groups of people who operate under the umbrella of the SBA, and it's called SCORE, Service Corps of Retired Executives. And all you need to do is link up with them wherever you may be and tell them what your needs are. You may say, I need help setting up an accounting system, or I want to know what my compliance requirements are, or what would be a good marketing strategy for me, my business, because there's this enormous foundation of knowledge across this group of people. The other group that is a comparable group, in fact, I actually was a member of it. It's an SBA-sponsored group, and it has a fun little acronym. It's ACE, and ACE in that context stands for Active Council of Executives. Again, it's populated by people who have significant knowledge in a particular domain, but they're not yet retired. After I started my business and realized how powerful this program was, this SCORE program was for the SBA, I learned that there was an active component, the Active Council Executives, and I volunteered, and I probably did that for 17 years. I would present half-day seminars on accounting and taxes for new business and things like that. So my point is, this stuff is free. The counselors, whether they're SCORE counselors or ACE counselors, will meet with you repeatedly. And you don't, it's not a one-trick pony. You don't just get to ask one question. You may say, right now I need marketing help. Later I may need help with intellectual property, if I need to patent something. So please understand that that's a really important resource as you're considering the legal framework of starting a business. I also want to share something with you that I know of, but I have no personal experience whatsoever. I've never done any work with intellectual property because, except for the copyrighted instructional materials that I haven't done anything that is intellectual property. I've not patented anything or sought a trademark or anything like that. But if you do, if anything you do in the course of business would give rise to intellectual property, and again, we'll talk about that more, the U.S. Patent and Trade Office actually has pro bono legal counsel. They have attorneys who understand intellectual property who literally belong to, they're employed by the U.S. Patent and Trade Office, and they have programs to support entrepreneurs so that you know how to file a patent application, whether it's a provisional patent or whatever the case may be. So I want you to know that there are two federal agencies, the U.S. Patent and Trade Office and the Small Business Administration, who literally every day of every year have resources to help you as an aspiring entrepreneur with legal and intellectual property concerns. I'm still rattled about the pencil sharpener. My goodness. All right, so I'm in the text now, 417. On that page of the textbook in chapter 15, there's a discussion that begins about the types and forms of legal structures for businesses. And essentially there are 5 that we're going to explore, and I'll put them on the whiteboard because I want you to have this framework, and then together we'll talk about each of them. I just put proprietorship on the board. The word that I'm working on right now is partnership. Now, I'm going to push over here a little bit farther. There are literally 3 types of corporations that I want you to be aware of. And we'll talk about these in depth. C Corp, S Corp, and LLC. So again, this little framework that I've just put on the board, 5 types of legal types, structures of an organization. Proprietorship, partnership, and then there are 3 types of corporations. Subchapter C, subchapter S, and LLC. LLC is a pseudo-acronym that means Limited Liability Company. So we're going to talk about these, but again, I wanted you to be able to, to have a framework that would permit you to grab information. So, a proprietorship is simply an individual, that could be you, who chooses to do business in an unincorporated form. It is easily, by far, the simplest form of business because you don't have to do anything. But it's ill-advised. I don't care what the circumstances are. To be a proprietor is ill-advised. There are people that do it, but then again, there are people who do all kinds of dumb stuff. Yes. One of the many reasons being a proprietorship is ill-advised, it's a very poor decision, is the proprietor, whomever he or she may be, has unlimited personal liability. What if you decide to open a fun little restaurant somewhere on the coastline near Savannah? And because it's almost expected, you deliver stuff. People, yes, you'll serve in the dining room, yes, you'll have a takeout capability, but many people expect or need delivery. Now, could you link up with DoorDash or Postmate or Uber Eats? Of course you could. But a lot of people don't do that. Look at all the pizza places that have their own drivers. Jimmy John's has its own drivers. So what if you have this fun little restaurant near the coast, near Savannah, and you hire some kid as a delivery driver, the kid gets in an accident and somebody sues. And the courts say, okay, we're going to award $4.9 million because your driver was negligent and somebody killed the baby or your food was cold when it got there. The point is that you have unlimited personal liability for any agents that work for you. So there's no tax benefit whatsoever to being a sole proprietor. And the sole proprietor, whomever she or he is, has unlimited personal liability. So excuse me for just a second. Don't ever be a sole proprietor. Dumber than a rock. The second choice is to be a partnership. Definitionally, a partnership is an association of 2 or more people who choose to do business together and to be unincorporated. A lot of businesses are partnerships. There's the first thing I would say to you about partnerships is it could be 2 or more. You could have 10, 18. I don't think there's a limit to the number of partners. And the contributions and the rewards that each partner makes can be unequal. Here's a what if 2 of you and I start a business And we realized that one of you is really, really strong operationally. You can get stuff pushed out the door, high quality products or services to our customers. And the other person is uncommonly good at marketing, whether it's creating a social media campaign, coming up with a strategy, product placement in stores, it doesn't matter. So one of you is the operations chief, and the other one is the marketing chief. You are absolutely critical. You are central to what we do, because either the register wouldn't ring or we wouldn't have any stuff to sell. So one of you is operations, one of you is marketing, and I'm the back end guy. I open the mail, I pay the bills, I file the tax returns. So here's my point. Among the three of us, we could say, if we have profits, operations gets 40%, marketing gets 40%, and Norton gets 20%. We could look at our relative contributions to this business entity and decide on an unequal profit share. We could also say it's down the middle, third. But my point is, you can have unequal contributions by partners in terms of capital or talent, and you can have unequal distributions to partners. The thing that is unnerving about partnerships is it bears similarities to a proprietorship in the sense that you're individually liable. But here's something I want you to hear, loved ones, and if this doesn't scare the crap out of you, I don't think you should be in the College of Business. I think you ought to be doing gender studies or something like that. Go join the human subjects school, be a psych major, yes. They do that when they're sophomores, they get extra credit. Pretty scary kids. In a partnership, anywhere in this nation, anywhere in this magnificent nation of ours, partners are jointly and severally liable for all of the behaviors and actions of their other partners. Let's pretend for a moment the three of us are physicians. We're all in some sort of a medical group here in the borough. And each of us is equipped. We are credentialed to perform surgery. I don't care what the surgery is, it doesn't matter right now. So, I'm partner one and you're partner two and you're partner three. So, partner three does a surgical procedure that's just so wrong, I have no words for it. Don't care what it is. It could be that the patient was in there to get surgery on the left knee. My partner misheard that and he gave the guy a vasectomy. Left knee, vasectomy. I could see that happening. Yeah. So, the patient for partner three, whose surgery was botched, sues partner three for $25 million and wins. Well, let's assume partner three sort of lives too high. It's a man, he has cars and jewelry and fancy suits, and he chases painted women, but he couldn't put his hands on $150 in cash. Okay, so partner two and partner one are jointly and severally liable. The plaintiff's attorney, the patient's attorney, could come after me for the $25 million, or after the other person for $25 million. So in a partnership, not only are you liable for your own actions, your own behaviors, you are jointly and severally liable for the behaviors and actions of all of your partners. Again, don't do it. Very bad decision. So now I want to talk about the various corporate forms. A moment ago, I said one of the forms is subchapter C, another is subchapter S. These are simply subchapters of the Internal Revenue Code. It's an enormous document. I can't even remember how many pages it has, but it is the Internal Revenue Code describes federal taxation in every possible form that it exists. So one of the subchapters in the Internal Revenue Code is subchapter C, and it deals with taxation for a traditional corporation. Another subchapter is subchapter S, and the subchapter S corporation has some similarities, but very substantial differences from a traditional corporation. So let me talk about those two briefly, and then we'll jump on the LLC thing. Subchapter S is a traditional corporation, as I said. All corporations have perpetual life. They live on forever unless you file articles of dissolution. The only liability that any investor, that any stockholder has in a Chapter C corporation is subchapter C corporation is the loss of your investment. If you put in $5,000 to buy stock and there's a $20 trillion award, it doesn't matter. The plaintiff is stopped at the corporation. You are protected. The corporation is a shield. that protects you from personal liability. You can lose your $5,000, but all you lose is, the max you can lose is your investment. You have no personal liability because a corporation is an artificial person. It doesn't get to vote, it can't have a baby, it can't be drafted, but it can enter into contracts, it can sue and be sued, it pays taxes. So all corporations are literally, in the eyes of the law, a corporation is an artificial person. So, subchapter C, as I say, is a traditional corporation, and you will hear people who are woefully uninformed. I think we call them economists, just a guess, I don't know. And they'll talk about double taxation. Well, double taxation could exist, but once again, if you're that stupid, you don't need to be running a business. Double taxation means that you and the C Corp, you make a decision to pay a dividend. And what that means is the corporation's already paid taxes on that dividend because it's not deductible, and then the dividend is taxable to the stockholders. That indeed would be double taxation. I don't think anybody's that stupid. Big corporations have to pay dividends to attract capital. But there's so many things that they can do to minimize, lawfully minimize their tax obligation. So in the context of a small business, when I say small business, I mean one in which ownership and management vest in the same persons, and that's what I'm talking about. In the context of a small business, double taxation is a practical statement, doesn't exist because nobody's that dumb. S Corp, subchapter S of the Internal Revenue Code. It has the same structure essentially in the sense that it's an artificial person, it has perpetual life. There are some structural limits. When I say structural limits, I didn't check this before I came or prepared for class this morning, but I believe that a subchapter S corporation has an upper limit of 75 on the number of stockholders. I think tax law says that an S Corp can only have 75 or fewer stockholders. A C Corp can have hundreds of thousands or millions. There's no upper limit. So that's the only structural limit that I can think of, is the fact that there's a cap on the number of shareholders. There is a radical difference, between a C Corp and an S Corp, and that's why people make that choice. Do I want to be a C Corp or do I want to be an S Corp? The radical difference is C Corps are taxpayers themselves. If a C Corporation, I'm going to make this up, if a C Corporation has $200,000 worth of taxable income, we would think of that as net profit, wouldn't we? Then the corporation will pay corporate income taxes on that $200,000. And I think right now, because of the positive movement of the Trump administration and the first Congress of his presidency, that the corporate tax rate is now capped at 21%. Prior to the Trump administration, it was 39%. Now, I'm going to save you the math. That's just about double, isn't it? Not precisely, but just about double. So my point is, if a C Corp has taxable income, it will pay corporate income taxes. If an S Corporation has taxable income, let's take the same $200,000. Let's assume that you have the same business, but you chose to be incorporated under subchapter S. The S Corporation is a conduit, and the net income of the business flows through to the stockholders based on their rateable ownership. So if I own 40% of the stock of an S Corp, and the corporation has $200,000 worth of net income, I am going to pay personal income taxes on $80,000, 40% of the 200. So an S Corporation is a conduit. The entity does not pay corporate income tax. Rather, the stockholders pay personal income tax based on their rateable share of ownership. So the primary difference between a C Corp and an S Corp, the primary difference is the fact that one is a taxpayer itself, the other is a conduit. The S Corp does not pay taxes, but rather the stockholders do based on their ownership of stock. In the C Corporation, it pays corporate income taxes. So the only way, and I mean this because I did this for most of 2 decades, the only way that you could make a decision launching a business, if you should be a C Corp or an S Corp, is to talk to competent tax advisors who know both your personal affairs and the business. And your CPA may say, gee, I think it should be an S Corp for these reasons, or I think it should be a C Corp for those. And I want to point out that if your circumstances change radically, you can literally move from C to S and S to C, but you can't do it every year. All I'm saying is we, those of us who are not active tax practitioners, simply do not have the credentials. We don't have the bandwidth to make that decision. So what we need to do is we need to go to someone who is competent. A CPA who was an active tax practitioner, and lay out, here's my last year's tax returns, here are my personal affairs, here's what the business is doing, what is your recommendation? Should I be a C Corp or an S Corp? Or LLC, which is where we're headed next. All right, I'm going to give you a highly technical description of an LLC. It is crazy good. I mean, that's the highly technical thing. Again, LLC means limited liability company. I actually have something, that I can share with you anecdotally. Let me tell you about my LLC. It is still active with respect to its corporate registration, but we haven't done business actively since maybe 2015. When I first moved here, I moved here in 2008, and I started racing because of our proximity here to Roebling Road, and I got very, very active in the Sports Car Club of America and raced all over the Southeast. And so I created an LLC, a limited liability company, called Three Trick Ponies, because at the time, I spent a couple of summers working in a Corvette resto shop when I was in Louisville, and I had some reasonable experience and competence there. And I love Mustangs all of my life. I have raced them, restored them, upgraded them, collected them, been a very, very active member of the Mustang community. And I love Cobras. Now, I can't afford an actual Cobra from Shelby, but there are all sorts of excellent reproduction cars. There's a South African company called Super Performance that makes one. There's a company somewhere, I think in New England, called Factory 5. But my point is that I went to a 3-day school at a tech school somewhere in the Midwest, like maybe Michigan or Illinois or somewhere like that, to be certified, to become qualified to build Factory 5 Cobras. So my point is the Three Trick Ponies were Corvette, Mustang, Cobra. I was going to build Cobras, restore Corvettes, and upgrade Mustangs. Three Trick Ponies. We were so clever, right? So I did this as an LLC because here's what it cost for me to start an LLC: $1.25, literally. There's a name reservation for $25. You send a $25 check and your top three choices, and almost inevitably you'll get one. So the point is that when you do this with the Corporation Commission, I think it's the Secretary of State, you get a name reservation for $25, and then when you submit the actual charter to become a limited liability corporation, there's a $100 filing fee. That's it. No attorneys, no big money, $1.25, you have an LLC. Now, the significance of that is its simplicity. That's one. The fact that it's unbelievably cost efficient. And the most important thing is not the simplicity or the low cost piece, but the fact that you are now a limited liability company. Get the name limited liability. The only liability you have is to lose your investment. If anything happens, lawsuit, anything else, it starts at the corporation. The corporation is a shield. You have no personal liability if you're acting on behalf of the entity. So when I said crazy good, I mean that. All it costs after you start an LLC, there's no corporate income tax to return, to file, or anything like that, because it's a conduit. If you make money, you'll pay taxes on it. If you lose money, it reduces your taxable income from other sources. So the LLC is a conduit. Any income or loss flows through to you as an owner. And the only thing you have to do to keep it alive is pay an annual filing fee of $50. We keep Three Trick Ponies alive. I keep it alive. I'm the only member. It's a sole member LLC. I keep Three Trick Ponies alive because I can visualize me doing something else in the future that is an active business, and I have an existing entity, don't I? I have a limited liability company that's active, registered with the Secretary of State, and I can start doing business tomorrow if I wished. So my point is, of the 5 choices, if you are an aspiring entrepreneur, I know this is me giving you a form of advice, and I shouldn't do that. But remember, I'm a recovering CPA. Not only do I understand this stuff well, I did it. I advise clients, I run businesses that I own. I can promise you, if you're an early stage company, the only thing that you should consider is to immediately be an LLC. Don't wait. Don't make that year 2 or when you make 30,000 bucks or whatever. The day you start active operations, do your name registration, or reservation rather, and file that thing. You need to be an LLC from day 1. Now, if you get big and there are benefits to becoming a C Corp or an S Corp, if you're big, you're going to have good counselors, aren't you? You'll have competent CPAs and that sort of thing. And they might say to you, Goober, you should be an S Corp for these reasons, or a C Corp for those reasons, or stay an LLC. But you and I, as non-practitioners, simply do not have the credentials or the knowledge base to make that decision. We need to rely on people who have domain competence in tax law. But I just want you to understand that, hands down, LLC is the best choice for any early stage business. If you get big and famous and all sorts of things like that, you may be well advised to choose another form. But do not be unincorporated, and in the early stages, there's no benefit whatsoever to you being a C Corp or an S Corp. It's much more complex and much more expensive. The singular best choice in any early stage business is an LLC. Now, I just shifted gears, but you knew that. I have a friend who bought a Jeep Wrangler a couple of years ago. He bought a new one, nice one, kind of a churched up version. And I don't think this was unkind, it made me laugh. He drives around almost all the time with the doors off, and he leaves the keys in the ignition. And I said, isn't that a little risky? He said, no. He said, I have a manual transmission. He said, I love this, I bought the millennial anti-theft option. And what he was suggesting, now you're not millennials, you're Gen Xers. He was suggesting that no millennials know how to drive a stick shift. And I think he might be right. But he got the millennial anti-theft option. He got a 6-speed transmission, so he leaves the keys in the ignition because nobody can steal it. Cracks me up. That was the gear shift thing. I had to make sure that you knew. All right, so now we're on 423. We're going to talk about intellectual property. IP is a big footprint. It covers so many things. Oftentimes we think about intellectual property as being a patent on a thing. And of course it is. But if you write a song, loved ones, that's copyrightable. If you look at every video I posted on YouTube, unless I drop the ball, the first thing it says in the description is copyright Bill Norton and then the year. If you write any kind of a manual, a children's book, anything, if you create art, all those things are intellectual property. Yes, you can invent something. I get that. You could also patent a process. 20-something years ago, Amazon patented its one-click ordering thing. You know, the buy now feature? Apparently nobody else can do that lawfully. Ford, decades ago, patented that keypad on the door where you enter a 5-digit code to get in. I know people that only buy Fords because it's the only company that can provide that in its vehicles. I mean that. I have friends that are driving Expeditions or other Ford products because they want to be able to leave their keys in the vehicle locked, and when they walk up to it, tap on the keypad and enter the vehicle. So my point is that intellectual property, yes, can be for things, but I want you to understand that so many things that are patentable or copyrightable are intangible. We can't touch them or see them or feel them. So we're like a song or whatever the case may be. So slogans, logos, books, software, artistic works, there's so many things that intellectual property covers. Now, I do not have significant domain knowledge in intellectual property. And the two reasons for that primarily are, I've never done anything that gave rise to intellectual property. That's just been the path that I've gone down. If I write an article, it's published. I don't own the copyright. The copyright belongs to the journal that published my article. And we'll talk about the relationship of employees and IP in a moment. But I want you to understand this. The only source of good intel on intellectual property would be attorneys. my understanding, I've never practiced law, my understanding is that the only two types of law in which attorneys may declare specialization are admiralty law, laws on the high sea, and intellectual property. You may say in your advertisements, we are personal injury attorneys or whatever you can say, but you are not declaring a specialization. Attorneys who practice admiralty law and attorneys who practice intellectual property law are the only two types of attorneys who can actually say, I specialize in this and I can make that declaration. So if you need IP guidance, you have to go to an attorney. Now, if you're trying to patent something, if you're actually trying to do that or get a copyright, you have that pro bono resource at the U.S. Patent and Trade Office. They actually have on staff attorneys who can guide you, who can tell you the process, what needs to be done in what sequence, and that sort of stuff. But the reality is you may need to have your own counsel and simply suck it up and pay them and be able to have those relationships. So I'm on 424 right now, and there's a discussion in the text about the rule of law, and I think that's pretty big stuff. We're a nation of laws. That's been true since the Constitution. The Constitution was ratified by the 13 states in 1791. I remember that clearly. I do. I wasn't one of the signers. I think I was next door playing cards with somebody. I think that's what I was doing. I'm a terrible poker player. You know that. I burst into laughter all the time. All right, so we're a nation of laws, and that is so good in so many ways I can't even describe it. One of the things that primarily comes out of this rule of law thing is that our property is protected. My truck is sitting out in the parking lot on the north end of the building. That is my truck. You don't get to take it unless I decide to give you the keys. And if you take it, you've committed a crime. And not only will I recover the truck, but you will have bracelets, stripes, and a lot of new boyfriends. Yeah, that's what will happen. Without the rule of law, there's anarchy. People do whatever the heck they want. I just described Portland, Oregon. Portland is past 50 days of active, violent protest. Not people waving banners, but active, violent protest. More than 50 consecutive days. And that's because the Portland leadership, boy, I have a hard time getting that word out. Those two together, Portland and leadership. If you think about the mayor, the city council, they've shut down the police. They've said, don't engage these people, let them do what they want. Are you kidding me? That is woke on steroids, loved ones, and that is so wrong, I have no words for it. So, the rule of law says, among other things, that we have ownership rights in property. It's ours, nobody else can take it. I can sell it, can't I? Or lease it, or convert it to something else. But the point is, property has ownership rights, and that's the significance of the rule of law. Now, as we talk about intellectual property, if you create something that legitimately is intellectual property, you are the sole owner. If you patent something, that means if it's what's called a utility patent, I think it's 17 years. For 17 years, nobody else in the United States can manufacture or distribute that thing. If you want to sell that right, you can. Here's a fun example. What I'm about to say isn't true, but boy, I wish I were the guy that invented the intermittent windshield wiper. I wish that I were that guy. But I have to build a factory and make millions of these things? Heck no! I would enter into a licensing agreement with Ford Motor, Fiat Chrysler Automotive, General Motors, BMW, and in every one of these agreements, they pay me several million up front and then a royalty, $1 or $2 every time they sold a car with my intermittent wiper thing on it. Because if I have the patent, it's my property. Now, since it's my property, I can enter into a licensing agreement, can't I? I can license some other entity to manufacture and distribute it. But the licensee has to pay me money, some up front and some on a recurring basis, royalties. So my point is that if you create intellectual property, if you own it, you're in a remarkably good place in terms of you realizing its commercial potential. Now, that means you have to take it to market, doesn't it? Now, here's something I want you to understand, and this is a very big deal. I don't think I was really aware of this until I spent time at the University of Louisville. When I was at U of L, I was actually on the university's IT committee. We had a university level committee that dealt with intellectual property. I meant to say IP a moment ago. If I said IT, it was a slip, forgive me. So I was on the University of Louisville had a standing committee, university level committee, representatives from each of the colleges and some of the administrative units that dealt with intellectual property that was created on our campus. And of course I became sensitized to the fact that we had a really robust, very well regarded School of Engineering, the Speed School of Engineering. And the faculty in the Speed School just were monsters for generating patent applications. They would discover all sorts of things that they thought had commercializable potential, so they patent them. And I mean like maybe $2,500 a year just from the faculty at one college. It doesn't matter what the precise number is, but here's the reality. If you are an employee and you create some intellectual property that's patentable, the patent rights do not accrue to you because that was your day job. You were paid by your employer to do that. So there's no residual interest. They don't say, okay, we get 80%, you get 20. None. The ownership of the property goes to the employer because the employer paid you to do that work. Now, could they pay you for 40 years and you never patent anything? Yes. And that's part of the rationale. But I want you to understand, if you're working for somebody and in the ordinary course of your work, you literally develop something that's IP, that's intellectual property, you don't get to submit the patent application. The university does, or your employer, or whomever it is you're working for, whomever is paying you to do that work. It's just well that you understand that. So I'm on 426 now, and 1, 2, 3, 4. There are 4 types of intellectual property that the authors talk about. They talk about copyrights. Copyrights are typically on things that are written or things that are viewed, like I copyright my videos, don't I? Another type of copyright is a trademark or a service mark. You will see many, many products that have a little R in a circle, or maybe a C in a circle, or SM, service mark, or TM. But the point is, if you look at, I don't have, I wonder if this is copyrighted. No, I can't find a copyright mark. If you picked up a bottle or can of Coca-Cola, that is K-O-K-O-L-A, because you are Southerners and you know the proper spelling of Coca-Cola. There are people in other places like Detroit that think it's Coca-Cola. God love them. Hope that they're doing okay. So you pick up a can or a bottle of Coca-Cola. Right after you see the Coca-Cola, there's going to be something in a circle, trademark, service mark, whatever, that are for registered, that will indicate that that term, Coca-Cola, I know, is literally has a trademark or a service mark on it. LG, the big Korean electronics company, LG, I don't know what the LG stands for, somehow, they got a trademark or a service mark on a very simple sentence that says, life is good. Do you see the L and see the G? Pretty darn clever, those Koreans. So there's so many things that are like that have our intellectual property, trademarks or service marks. Trade secrets, yes. Trade secrets is another form of intellectual property. You create something in your organization and you don't want it distributed. You don't want your competitors to know about it. So you are protected there. And then of course traditional patents. And I'll talk a little bit about patents in a moment because that is the most visible, I guess. But I want to talk to you about something that's introduced on page 427, and I really want to spend a minute or two with it. I want to be abundantly clear that ideas are free. If you have an idea for a concept, a product, a process, it has no value. I have hundreds of ideas every day. They have absolutely no value until I take that idea to market. And the reason that sometimes is almost comical, I've seen very, very early stage entrepreneurs who had an opportunity to talk with an equity financier like an angel or a venture capital firm or something. And these young naive entrepreneurs actually pushed a document across the table, and they wanted the VCs to sign a non-disclosure agreement. And the VCs would, if they're smart, they just pick it up and send it to the shredder. Your ideas have no value. Nobody's going to say, I'm not going to openly and freely discuss this with you or anybody else, because ideas are free. Over the course of my life and your life, you and I will have millions of ideas. But until we take them to market, until we commercialize them, they have absolutely zero value. And again, the text makes that clear, and I want you to be aware of the fact that you don't need to worry about being secretive with your ideas, because they mean spit. When you commercialize an idea, that's different. That's different. For example, if you launched a business, actually launched a business, you have traction in the market, you're making and selling stuff, whatever you do, and you want to have a relationship with private equity financiers so that you can fund growth stages in your business, then you have a viable existing business entity. You have a concept. You're taking products or services to the market. It's no longer an idea. So if you want to take a business plan, a proposal to an equity financier, and you say on the face page, this is a limited distribution, your eyes only, don't give it to anybody else, that's legitimate. That's legitimate. But nobody's going to sign an NDA, a non-disclosure agreement, because again, that's not going to happen. So now, I'm on 428. I want to talk about global theft, because that's what the authors talk about on 428. I cannot think of a better example of global theft than China, because China for 25, 30, 35 years has been actively engaging in global theft, making counterfeits of legitimate products, literally cyber theft, paying people in university settings to do research, to spy, stealing military secrets, industrial secrets, forcing American companies who want to do business there to reveal all their proprietary tech. China is probably the single biggest thief in the world of intellectual property, really is. And I'm thankful that our current administration is making a concerted effort to shut it down. I am. But I want to talk about other things too, and this particular thing is not necessarily Chinese, though I don't know its source. A number of years ago, I was in the Atlanta airport, and for 22 years I wore a Rolex. I've moved to Omegas now, but that's not even remotely important. I was at an airport, and some observant thief saw me, and he said, "Hey man, you want to buy a Rolex?" And I said, "Well, I have one, I'll consider it." He knew that. You can see it was on my wrist. So he literally, this is like a guy flashing somebody. He had on a trench coat of sorts, and he opened it up, and there were watches in straps sewn to the inside of his trench coat. And he took one out, and I looked at the face, and here's what it said on the face of the crystal: Rolex, ROLLEXX. Okay. I said, no, I'm not really interested. Yeah. My daughter had a dear friend of hers give her a gift. It was a Gucci bag. Some people think it's Gucci, but if you just look at it, it's Gucci. It wasn't a real Gucci. It was a counterfeit Gucci. The kid that bought it spent $100 on it. A real Gucci bag would have been $1,500. So this thing about global theft, about counterfeiting and literally stealing industrial and military secrets is just everywhere. It really is. And the point is that if you do get intellectual property protection, that only protects you in the United States. Somebody in Germany could look at what you're doing and say, I'm going to do that, and you have no protection whatsoever in Germany or Europe or anywhere else out of the United States. So you just have to be sensitive. If you do indeed own intellectual property, if you create it and own it, you need to be sensitive to find ways to protect it. I'm on 430 right now, and I want to talk to you briefly about provisional patents. Please appreciate, again, that I don't have competence in that domain. I'm not an IP attorney, but I understand it vaguely. If you submit a provisional patent, what you're doing is you're essentially protecting whatever it is that you're working on. You immediately, at the moment you file the patent application, it doesn't have to be approved. At the moment you file the patent application, you have protection. That property is your property. However, a provisional patent only gives you 12 months to finish development. So in that 12-month window, if you file an application for a provisional patent, just protect something because you're working on it. At the end of that 12-month window, you either have to literally finish the filing, you have to complete whatever the patent process requires, and if you don't, it lapses, and everything that you put in the USPTO is now in the public domain. I can go on their website and look at your drawings and read your narrative and absolutely build and take that thing to market. So I want you to understand that provisional patents are really unbelievably helpful in the sense of grabbing immediate protection for something you're working on. But if you don't think in the next 12 months that you'll be in a position to perfect the thing and finish the patent application process, whatever you've done, you no longer have protection on day 366. And everything that you have put out there in the USPTO website is now in the public domain. Now, this doesn't distress me, but now in the text we're going back, we're leaving intellectual property, we're going back to legal concerns of a business. We talked about the structural pieces a few moments ago. So right now I'm on 432, and the authors want to talk about human resource laws and related sorts of issues or problems. The first thing they talk about is the EEOC. The EEOC is a federal agency. It stands for Equal Opportunity Employment Commission. And the EEOC, literally, if you file a complaint with the EEOC, or think about this, loved ones, if one of your employees files a complaint with the EEOC, what the employee has to allege is you are creating a work environment that's either discriminatory or it's a hostile workplace. If your complaint addresses either of those concerns, the EEOC will literally dispatch a team and do an on-site investigation and make a finding, and they wield enormous power. But that's where the EEOC is operative. Do you have a workplace where discrimination is active in any form, or do you create a hostile workplace where people are really profoundly uncomfortable coming to work because you permit things to go on that you shouldn't? There are all sorts of taxes and insurance. They talk about workers' compensation, payroll taxes. I think that these sections are best left to your reading. I really do. Both of them, workers' comp and payroll taxes, are really important compliance requirements. And if you're in business, you will have to comply with them. And if you simply have an awareness from this discussion that you need to, we've accomplished something meaningful. On 436, they talk about an employee handbook. And here's, I almost think that this is unfortunate. Nobody, anywhere, is required to have an employee handbook. I think that's so stupid, I have no words for it. Now, speaking of stupid, when I practiced as Bill Norton, CPA PC, and I was 100% stockholder in a professional corporation, did not have an employee handbook. When I merged my firm with Powers, Bowl, and Lee Farmer, we did not have an employee handbook. But I also want to point out that that was 30, 35 years ago. Well, when I started it, it was 45 years ago, and I practiced for 17 years. So my point is that we didn't have an employee handbook, and that is so stupid. Here's what an employee handbook should do. It should say, here are the conditions of your employment, here's your starting salary, here are all the compensated time off things, vacations, holidays, sick leave, here are our expectations in terms of code of conduct, here's our dress code, here is an ethics hotline thing, or ombudsman, or whatever path you need to go down. If you have any grievance, here's the pathway for filing it. I think absolutely every organization should have an employee handbook. Now, how tough would it be for you to start a business? Think about this. I'm throwing an opportunity out there. I hope somebody grabs it. You start a business where you build sort of a prototypical employee handbook, and then you just simply modify the text to match up with your client's needs. Could you build an employee handbook that talks about 15 or 20 different pieces of the puzzle? Compensation, health insurance, Family Leave Act, all this stuff. And then just literally, you have this stuff saved in an electronic file, you just modify it to whatever I do for, like if I say, for example, you're eligible for vacation after 1 year of service. After 2 years of service, forgive me. After 5 years of service, you're eligible for 2 weeks, or whatever I say. You see my point? You could build a model employee handbook and then offer it for sale all over the nation, recognizing that they, whomever your clients or customers are, would just have to fill out a questionnaire so that you would have specific changes that literally match up with their business needs. I think it's a fabulous business opportunity. Remember what I said earlier about ideas being free? That's an idea. Does it have any value? No, because I'm not acting on it. I would be overjoyed if one of you does, because I think it's pretty clever. Now, you really need to plug in with some people in HR so that you don't swing and miss on some very important topics. But I think, now if you had an employee handbook, here's what I think should happen. Within 1 week of people reporting for work, they have to sign a document and give it to you that says, I read every page of that, I understand that I'm in full agreement. If they don't do it, you release them. How easy was that? So, employee handbooks are not required anywhere, which is just stupid. And they're enormously helpful, and I see a business opportunity for someone to create sort of a baseline, a prototypical handbook with all these topics dealt with. And some of them would be universal everywhere, like compliance, taxes, and things like that. But others would be employer specific, like what are the provisions here for, my son worked for FedEx for 2 years. He was a permanent part-time employee. He was on a 30-hour schedule. The reason that FedEx made him permanent part-time at 30 hours a week is FedEx at 30 hours a week had no obligation to provide health insurance for him. Golly gee. Well, his wife was well employed and she had health insurance, but that's just, what if Zach were single? Anything happens, it's on him. Not good news. So my point is that employee handbooks, in whatever form they exist, would make significant policies abundantly clear. And the requirement would have to exist for all new hires to read and sign this thing and give you that document that said, I read the thing in its entirety and I fully understand and agree. That's it. What happens when you order stuff online? Terms and conditions. Yes, I agree to the terms and conditions. If you don't click that, you don't get to make the transaction, do you? So all I'm saying is I wish everybody had employee handbooks. Because that takes, there's no he said, she said, there's no, well, I didn't know about it, there's no, what the heck, that's the deal here? I'm not gonna work in this place. I think employee handbooks are powerful stuff. Now, I have 2 more topics before we wrap up today's session. One of them is, I'm gonna take them slightly out of order. One of them is unpaid internships, it's on 438, and I'm gonna take them out of order just because it's easy to deal with and I wanna put some stuff on the board for the other topic. So, excuse me, please. Here's the reality of unpaid internships. They are generally illegal because of the Fair Labor Standards Act. We've had federal law for decades that said not legal to do that unless the internship is for academic credit. And the reason is so straightforward. You don't get paid to go to any other courses, do you? Why would you pay to get 3 credit hours, academic credit, for a 15-hour-a-week internship somewhere? So unpaid internships are generally illegal. I mean, it's in the Fair Labor Standards Act. It said that cannot happen unless the internship is being done for academic credit. Now, are there companies that pay and even pay well for internships? Heck yes, all over the nation. But the companies that pay for internships generally are using them as a filtering tool. What they're doing is they're auditioning you. Let me tell you something that you need to hear. We here in the Parker College oversee about 600 internships a year, and we have a woman, a very talented staff member, Danielle Smith, whose primary responsibility is oversight on these 600 internships because they're done for academic credit. And when I say to you that companies, especially the people who pay for internships, are auditioning you, they're looking at your attitude, your work ethic, your skills. And if they like you, they're going to retain you. And if they don't, they're going to say, well, thanks, it's been nice. Ah! In the Parker College, I've seen these data for the last several years, maybe the last 3 or 4 years. 93% of the students in the Parker College of Business who get internships get job offers. Because the companies look at you and think, heck, this is a good person. I want to keep this good person. She or he shows up for work, well-dressed, interacts with people, realizes that she or he has to make a contribution. That's why 93% of our kids who intern get job offers. Now, here's a fascinating paired fact to that. 93% of our kids get job offers and internships. About 55% of them take the offers. Well, I can think of 2 reasons. There may be more. Here's the first thing I can think of. If I'm an employer and I like you, other people will like you for the same reasons. Because you are high speed, low drag. Because you're bright, you've got social skills, you've got talent, you've got a good attitude, you've got a good work ethic. If I like you, other people will like you, and that means you'll have choices. I can't tell you how many kids have come to my office and sat there and say, I'm kind of struggling, Dr. Norton. I have 3 job offers active right now. Which one should I take? And I don't ever tell them which one to take. What we do is we talk through the attributes of each of them, and then the kid makes a good decision. I don't give people advice. I think that's stupid and arrogant. If I can help by sharing perspective, I'll do it every day. But my point is, the reason we have this big gap between offers and acceptance is, the first explanation is, if I like you as an employer, other people will like you. So you'll have multiple offers, you'll have plenty of opportunities. The second thing that's true, and this won't surprise you, what if I'm a junior or senior here at Parker College, and I do a summer internship, or whatever the case may be, and I've been there now for 8, 10, 12 weeks, and I think, I don't fit here. I don't see a way forward, a way to advance. I don't like the culture. I've seen unethical behavior. I don't know what the reasons are. But the second explanation for a lot of our kids declining is that they don't like the environment that they're in for whatever their reasons are. Now, the last thing I'll say about internships, and this is not in the text, is if you have an opportunity to take one, do it. I don't give a flip what you do. It doesn't matter. Employers don't care what you do. But it's a powerful line on a resume. And the reason it's a powerful line is all 100% of internships are competitive selections. That means among a pool of candidates, somebody chose you. So you bubbled to the top, didn't you? So internships are competitive selection. That's the first thing. The second thing is you now have been immersed in an organizational context. You know that you have to hit an alarm, get out of bed, shower, change, show up on time, be cordial, have good social skills, make a contribution, and learn at the same time. So people realize if they hire an intern, a former intern, they're getting somebody who's a grown-up, somebody who knows how organizations work. So all I'm saying to you is I'm a big fan, a huge advocate of internships, because it really sort of equips you to perform well in an organizational setting. And here, there's a pretty high probability you'll get a job offer. You don't have to take it. But my point is, I wanted to talk a little bit about internships. What the text talks about is unpaid internships. And it's well that you understand that the only ones that are can lawfully be unpaid are internships for academic credit. And that's because you're not paid to attend any other classes, are you? So the last topic I want to talk about is on 436. And the text makes a simple distinction between an employee and an independent contractor, and I want to put a couple of things on the board and sort of bring that to life. Rocket fuel. All right, 2 columns. Employee, independent contractor. I'm just going to talk about 3 things. Forgive me, 4. Okay, here are the 4 things. Remember, we have 2 columns, so I'm going to create a little matrix. We have a column for employee and a column for independent contractor. The four things I'm going to talk about are compensation, benefits. This meant, I know this is messy, but that's meant to be withheld taxes. And then this last line is tax due. So, and this is just conceptual. I'm not going to develop specific numbers, and I don't need to. Let's assume, I'm making this up, that you get a stupid good job out of here. You start out at 60,000 bucks a year. No, I'm going to change that. You start out at 48,000 a year, and you get another offer from another company that says 60 grand, but you're going to be an independent contractor. And you think, what the heck? 60 grand? Dang! I need to order my Lambo right now. Yeah. I like the emerald green one because you have to let me drive it if you do get it. That's a condition of being in 32, 34 for summer. If you get a Lambo, I get it every other weekend. I think that's, wasn't that when you registered? All right, so I'm talking about you. You're punching out of here, somebody offers you an excellent job at a great company, and your starting salary is going to be 48 grand. You get another offer from another company that says, we're going to start you at 60, but you're an independent contractor. And I don't say this to be unkind. I don't say this to imply that you are naive. But a lot of people will be seduced by the higher comp. 12,000 bucks is 25% of 48 grand, isn't it? You're talking about getting 25% more by going with this company. And when I say seduce, I mean an awful lot of people would think, I've got to do that. No, you don't. Bad decision. So, let me just for a moment focus on the employee. So, if you're an employee anywhere, you'll have benefits. You'll have health insurance. You'll be in a retirement plan. You may have a reimbursement for the fact that you have to use your personal vehicle. You may have gym memberships, all kinds of stuff like that. So the point is, there will be some money withheld for benefits. The company will withhold money for benefits. Another thing that the company is going to do is they will withhold federal and state income taxes. So you got some more withholdings there. Now, as a reality, I realize I'm creating this is a demonstration. As a reality, since your taxes are withheld, I would expect that you would have zero due. So you have excellent compensation, a good benefit package, and all your taxes are withheld, and at the end of the year you have nothing due. So, you're an independent contractor. You get zero for benefits, the big bagel, because you're not an employee. You're an independent contractor. The moment that I don't want you, I say, contract's done, you're over, bye. There are absolutely no taxes withheld. You know where I'm going. Because you're not an employee. So, taxes due. Well, poopy. Let me tell you about the taxes due. This actually happened. I had a student, an IT major, who had this very scenario. She was offered 48 grand to go somewhere as an employee and 60 grand by some company in Atlanta to be an independent contractor. And she came to me and she said, this almost sounds like it's too good to be true. And I said, it is. And here's why. So we had specifics here. So I literally made a phone call to Mrs. Norton, who is a CPA. Yes, I get to sleep with my accountant. It's pretty cool. Yeah, not everybody gets to do that. This student was a single woman, no children, so there was no other income on her tax return. It would have been hers and hers alone, and she had no dependents. So that year, the federal income taxes on $60,000 were 28%. Now, the taxes, you have FICA, Fed, and state. Elaine checked the tax rates for her at that level of income in the state of Georgia for that year, and the state income tax would have been 6%. Now, if you are self-employed, and all independent contractors are self-employed, you have to pay a self-employment tax slightly over 15%. I don't remember, it's like 15.3, 15.7, but it's over 15%. So, here's what we have. You have to pay 28% federal income tax, 6% in state income tax, and 15% of this self-employment tax. What that approximately equals, 28, 34, lest I embarrass myself, you'll be, let me make sure, yeah, that's in the camera. The taxes that you'll have to pay will be 49%. I think that's pretty close to half of what you earned. Now, the point is, you're not going to know that until March of next year. You go to H&R Block and you say, here's my income. I'll get a 1099 from this company that had me as an independent contractor. And H&R Block is going to say, well, you owe about $30,000 in taxes and $4,000 or $5,000 for penalties and interest for underpayment. And just write them a check. Yeah, that's it. So, do not, please, I beg you, this is not me telling you what to do, this is me begging you. Do not, under any circumstances, anywhere, consider going to work as an independent contractor. The company will dismiss you without cause, with no notice. I have a young friend who took what he thought was a great job with Home Depot as an independent contractor, and he got an email on Thursday that said, in an hour, we're locking you out of the computer system and you'll be escorted off the property. They gave him 1 hour notice and he was out of a job. That's it. No severance pay, no nothing. And he did not have any benefits, vacation, health insurance, anything like that. Do not consider under any circumstances. I don't care who it is. Gulfstream, I know in some of its departments like IT, the only path is contractor to employee. They don't even consider it. Well, don't work at Gulfstream. Don't put yourself in this situation where you have absolutely no benefits, you have no taxes withheld, you can be discharged in an hour for no reason whatsoever, and at the end of the year, I promise you, if you're single and you're in the state of Georgia, now if you're in Texas, they don't have an income tax. But I promise you, if you're single and in the state of Georgia or most of the other states, you're going to have roughly 50% of whatever you earn due in taxes in one check, loved ones, two. One to the state, one to the feds. Boom. Do not, under any circumstances, even consider taking a position as an independent contractor. If somebody offers you one, punch him in the mouth hard several times and leave. I know I just gave you some advice and I shouldn't have. So, that's it for today. We're going to end with the attendance verification question because that is so important. What was my chilling discovery today in room 1104 in the Parker College of Business? All right, love you. Talk to you all soon.